and also helping parties to manage their risk. So what I've been asked to talk about today is easements. Now, easements are absolutely crucial to the amenity of a property. They can cover all sorts of different areas, such as rights of access, utilities, rights of light, and rights of support. It's quite a complex area, and it has evolved over time. So today, all we're going to have time to do is take a very headline look at how easements function and how you might go about resolving issues related to easements when they arise. So what I thought we would start with is having a look at how easements are created. Then what I'm going to move on to is having a look at the scope and extent of easements, so you know exactly what your easement covers. Then we're going to have a look at protection, and then interference, and then remedies. And then I'll move on at the end to talk about how we might approach disputes in this area. So let's start with the very basics of easements creation. What you have is you have two pieces of land. You have what's called a dominant estate and a servient estate. So the dominant estate is the one that benefits from your easement. In this case, the example that I've got in the picture there is a right of way. And your servient estate is the one who gives service to that easement, essentially is the easiest way of recalling it. So in this case, in that picture, you can see that dominant parcel A has a right of way, so an easement over servient parcel B so that it can get to the road. So it gives it access to parcel A. They can be created in three key ways, which we'll break down in a bit more detail. So the first one is expressly. So that's when the parties have intentionally decided that they are going to grant an easement and recorded it. There are then a number of ways that they can be implied, and the implied easements tend to come about at the point when properties are sold or when part of a property is sold. And then you've got the old prescription rights, and these are the ones that arise over time. So express creation then, the most obvious one is by a deed. So the parties have decided that they want to grant a right of way, or they want to grant a right for someone to put utilities over their land, and so on. So what they do is they record it, usually within the conveyance or alternatively in a separate deed, and then that becomes a legal easement by express deed. The other option you've then got, though, is Section 65 of the Law of Property Act. And that says an easement might be created where there's a sale of part and the seller decides that they are going to reserve their rights over that. So what Section 65 actually does is it provides that it's not necessary for the buyer to actually execute the deed. So if, for example, you were splitting a piece of land and the person who owned the initial piece of land wanted to reserve a right of way, so thinking about our parcels A and B again, say that the party that owned those two parcels of land decide they're going to sell off the front garden for development, but obviously they still want access to their house. So what they do is they reserve a right of way across parcel B to get to the road. What effect that actually has in law is that essentially the buyer has granted a right of way to the seller when they bought part of that land. Now, in reality, when the transfer is filled out, that is generally completed by the seller and it is signed by the seller. So what Section 65 does is it says to you that the buyer doesn't have to execute the deed. The fact that part has been sold means that there is an effective grant there, despite the fact that it's not the buyer who's effectively put it into writing. It does lead us to a little bit of difficulty when we get to dealing with what's called the contra preferentum rule. And what this means is that where there's ambiguity, it's usually found in favour of the party who did not do the drafting. But because of the effect of Section 65, it's the buyer despite the fact they've not drafted the transfer, it's the buyer who has granted the easement. So if there's any ambiguity in the way in which that is drafted, it will be taken in favour of the seller, despite the fact that the seller is the party that drafted the transfer. So what that means is that you can't sit back and make sure and hope that your easement is going to be sufficient. If you are a buyer or a buyer's legal representative, what you actually need to do is make sure that there's no ambiguity in there, or else it could be the contra preferentum rule acts against you. The other options you've got for express creation are statute, and there's various statutes that can imply easements. One of the ones that commonly comes up is where there's anything like compulsory purchase powers. You'll also find that there's a lot of statutes that give special powers to utility companies, for example, gas, water, and electricity companies. The final one, which is one that often gets forgotten, is that easements can often be created by wills. So where you have a large estate and it's left to a number of different parties, then you will find that there will be some express easements that are created when that estate is split down. Implied creation, then. This is where it becomes a little bit more complicated. So your express easements, you'll find that they are recorded somewhere. It makes it easy to know where the easements are. It makes it easy to know what those easements are. Where they are implied, things then become more complicated. So this becomes an area where there tends to be more disputes and the law has become more complex. So it quite often is implied where either they're disposing of the land or they're disposing of part of the land. And they can be by reason of necessity, by common intention of the parties. The rule under Wealden and Burroughs, which was a particular case that set out a rule for dealing with this area of law. And then the other one, which sits slightly apart, is Section 62 of the Law of Property Act. Now, I'll run through these, but what you have to understand is that quite often all of these will be argued together. They're all slightly different, but they all arise in very similar circumstances. So what you often find is that they've been argued in the alternative. So by reason of necessity is probably what you would expect. It's something that you need in order to be able to make use of that piece of land. It's most often found when you're dealing with access rights. So say somebody has got a piece of land, they've bought part of a piece of land, and then they find that it's landlocked. So there would then be an easement perhaps implied over the neighbouring piece of land, which was an easement of necessity because they need it in order to be able to get to their land. The other occasion that it comes up with quite commonly is easements of support. So that's, for example, if you've got properties that are next to each other that require some sort of structural support, or indeed if you've got properties that are on a hill. So, for example, there's a requirement for the properties lower down the hill to offer some support to those further up. Similar to that, you then have the common intentions of the parties. Now, what this looks at is what was the intention of the parties at the time when the transaction took place. And then the court will look at that and decide to give effect to the manner in which the land was sold or retained and how it was intended to be used. It's very similar to easements implied by necessity, but you will find that the scope and extent implied by common intention can be a lot wider because it can go beyond what is merely a necessity to what was actually thought to be intended by the parties. What you need to be able to show to deal with common intention is you need to have some evidence that there's a common intention relating to the use of the dominant or servient land, and that there is an easement that was necessary in order to carry out that intention. So there's no other way of doing it without there having to be an easement there. So clearly it must have been the intention that an easement was meant to be in place. There is a difference in the burden for different parties to try and prove this. If you are trying to prove that there's an implied reservation, so for example, you're dealing with the party who has sold off part of their land but forgot to reserve their right of access in the conveyance, then you are going to have a much higher burden to try and prove that that right of access was intended to be there. So it's a lot harder to prove reservations than it is if you are perhaps the party that bought that piece of land in the corner and is now wanting to gain access across the remainder of the estate. The case of Wealden and Burrows is actually quite an old case. It's from 1879, and what it tried to do was to pull together some of the various case law at the time around the necessity and the common intention to try and give it a much more simple test. And it still continued to be good law to this day. So what this deals with is it acts in favour of a buyer, and what it does is it implies quasi-easements over retained land as long as they satisfy the following test. So if they're necessary for the reasonable enjoyment of the part of the land that has been disposed of, they have to have been used and still be in use at the time when that piece of land is disposed of, and they need to be continuous and apparent. Continuous means it can be one which is just enjoyed passively. It doesn't have to be something you actively do. So it could be something like a right to light, or it could be the case that somebody is on a relatively regular basis using a right of way and so on. It also needs to be apparent. This is not as strict as you might think it would be, because it doesn't have to be obvious that somebody is perhaps using, for example, an access way. If there is a path there or a roadway there, then it would be implied that it was apparent that it was in use. Similarly, if there are windows in the side of a building, then it would be implied that there was light being used through those apertures. So the rule in Wealden and Burrows again comes into play in that situation where it's in favour of the buyer of a part of land. You then have Section 62. Now, as I said, Section 62 of the Law Property Act 1925 sits somewhat to the side. Essentially what it is it's a word-saving provision. So it saves conveyances having to be incredibly long by making it unnecessary to set out a long list of what's being conveyed along with the land. But it is usually considered alongside implied easements because it results in the easements themselves not necessarily being written out in full within the conveyance. It does deem a number of necessary general words into the conveyance, passing a wide range of common easements, the usual things you'd expect for utilities and so on. It does apply to both registered and unregistered land. There are some limitations. It has to be things that the grantor had the power to grant at the time of the conveyance and that were in existence at the time of the conveyance. And also, it can be overcome if you put something in the conveyance which is contrary to the implied terms of Section 62. So if you want to avoid grants being implied by Section 62, the thing to do is to put them specifically into the conveyance. Again, looking at the wider avoidance of implied grants. What you can do is you can also put in some general wording, and there is some recommended wording that you can find in the Land Registry Practice Guide 62, which states that all of the easements that are to be conveyed with the land are contained within the particular conveyance, so none are to be taken to be implied, either by necessity, common intention, Wealden and Burrows, or indeed Section 62, and you can make it as wide or as limited as you need to, but there's some really good starting wording there. So moving on then to our third means of creating easements. This is prescription. So there are a number of things that need to be in place for prescription. It can be quite complicated and it can be quite confusing. But essentially, if you think that it is based on the principle that if a party has been exercising a right for a long period of time without interference, it should be capable of being legitimised by the court. It's interesting as well to remember that parties can, as in tenants, can exercise rights on behalf of a freeholder. So if a tenant, for example, has been making use of a right of way for the requisite time period, then it could have secured that right of way on behalf of the freeholder of the property. So you've got to be looking at all the occupiers of the property and what they are doing. Broadly, it can be acquired where the owner or occupier of the dominant land has used the servient land in a manner which could exist as an easement. So if they've walked across it, driven across it, put utilities across it, built something up against it, if they've used it in some way that would suggest that it could be capable of making that into an easement. The next thing is it has to be done as of right, and there's a nice bit of Latin there that gets quoted, which is nec fi, nec clam, nec precario, which means without force, without secrecy, and without permission. Now, without secrecy and permission is fairly easy to prove. Without secrecy, you've just treated it as if you've got that right. You've walked across the land. You've done what you need to do. Without permission, again, is fairly obvious, and that gives you a clue as to how you can stop prescription, which is if you put a license in place, then obviously prescription is not going to arise. Without force is one that's a bit more interesting, because force gives you the impression that you really have to do something like breaking onto the property or so on. It's not necessarily something that advanced, and I'll if I give you an example, signposts are something that comes up quite a lot, and thankfully this has been clarified in a case called Winterburn and Bennett, which I've put down at the bottom of the slide there. That was 2016. In that case, the landowner put up a sign saying that the land was private and only to be used by its customers. So the Court of Appeal found that the fact that they'd gone onto the land in spite of the sign was enough to suggest that they'd done it by force. So it is good news for landowners. If you put up signs around your property, you can prevent prescription of rights over your property, such as rights to park, rights of way, and so on. You need to make sure, coming back up to your requirements, that obviously competent grantor and grantee, that means that you need to have people in place that they've got the interests in the dominant and servient land. As I said before, the party who would get the benefit where you've got tenanted property is the freeholder, the landlord, if the tenant has been doing it as they seem to be using that right on their behalf. It also has to be something that if it were expressly granted, that it would be legal. So you can't, for example, grant a right of way over common common land because it wouldn't be legal for someone to drive over common land. So therefore, even if they've been doing it, it wouldn't be something that would be capable of being granted as an easement. And then the final common sense check, which is there's no other obvious explanation for use other than there must have been some sort of prescription there. So this is when we think then, how do we get to the point then of saying, okay, we've got all of those requirements in place, but how does that then operate in law? Now, the magic number there, which I've put, which you can see on your signpost, is 20. So 20 years tends to be the magic number for how many years that right has to have been exercised before prescription will be deemed to have taken place. But there are a number of different ways in which prescription arises, and these go back historically. So I'm just going to cover these very, very quickly in case you come across these terms. So there's the common law of prescription. The common law of prescription was that if there's an assumption that the use could be traced back to 1189, then it could be properly presumed that there was an easement in place. Obviously, we're not expecting people to track back all the way to 1189, so case law has dictated that actually if you can go back 20 years, it's presumed that it goes all the way back to 1189. Why did they pick 1189? Well, that is the limit of legal memory, being the year in which Richard the Lionheart died. So it's a nice bit of history there for you. You can rebut this though by showing that it hasn't in fact existed for the 20 years, or that at some point during those 20 years the dominant and servient land have been in the same ownership, because obviously if it's the same party that owns both parcels of land, even if they're separately registered, then clearly they're just crossing their own land. It's not a case of dominant and servient relationship. The law then moved on, and it developed what's called the doctrine of lost modern grant. And this essentially creates the myth that at some point in time there was a deed of grant and that the parties have lost it. And essentially how this works in case law is that if you've got 20 years use without any lawful explanation, then it must be assumed that there's an origin in a deed of grant that was made after 1189 and that deed has been lost. It's worth noting that it's not rebuttable if the easement is interrupted after 20 years. So if somebody has had 20 years continuous use at some point in the past and then it's been interrupted for a couple of years, they can still have an easement in place by the doctrine of lost modern grant. There's also no need to prove that a deed ever really existed. It's a myth. Or that the parties were ever involved in, or they're involved in having one. That was established in a case in Angus and Dalton in 1881, even though it was proved beyond any doubt that there was never actually any deed. It was found that the doctrine of lost modern grant would still take effect. We then move on to an attempt that was made in 1832 to try to draw the common law of prescription excuse me, and the doctrine of lost modern grant together, which was the Prescription Act 1832. It's not a very good piece of legislation. It's not something that is used very often because it was very poorly drafted. Essentially, it gives you two time periods. The first is it refers to the 20 years of use, and it says if you have a claim made against you, then you can say I've been using that for 20 years as a defence. And there is an alternative one, which is 40 years, which you very rarely see in practice. and that basically says that if you can prove that you've been using a right-of-way for over 40 years, then it's absolute and indefensible, and so that's going to remain in place. Now, the reason you don't see that very often in practice is because if you can get 20 years under common law or doctrine of loss modern grant, why would you be trying to prove 40 years under the Prescription Act? So why is it still good law? Well, it comes into its own in respect of rights of light. Prior to the Prescription Act, rights of light were very difficult to establish. But what this did was it allowed a right of light to be acquired after 20 years with the absence of any written consent. It doesn't require a user to have been of right. So the fact that they've just had light coming into a window of their property is sufficient. And it doesn't assume that the right lies in a grant or even that it was possible for the right of light to be acquired at the time when the easement started. So what it did was it created essentially the basis for the modern law relating to rights of light. So that's why you will still come across the Prescription Act 1832. One of the other things that's arisen out of that is light obstruction notices, which are worth knowing about, which is Section 2 of the Rights of Light Act 1959. Now, what these do is they help you prevent a right of light being acquired by interrupting the flow of light for a year. So what Section 2 allows you to do is to serve a notice, puts up a light obstruction notice, and what that effectively does in law is it creates a barrier, not a physical barrier, it's a legal barrier to say that the right to light is not continuing to accrue. They're very, very useful things to use when you're clearing off sites for development, or if perhaps you've got a brownfield site which has had development nearby and you don't want rights to be acquired while you're deciding what you do with that piece of land. There are some bars to prescriptive easements, which I've mentioned on there as well. Come back to that same example as we had with the implied easements. You can't have one where it's illegal, so not if you're driving over common land, or if you're doing anything else that would be considered to be illegal. And also it can be got rid of by unity of ownership again if the two pieces of land are brought into the same ownership. At some point that will stop the clock running, even if they're then separated again. So all of those that we've just discussed, these are all legal easements. Quickly have a think though, there are a couple of other easements that the court may imply, which are equitable easements. These are things which the court thinks it should be fair to put in place. The first one is that where a contract has been put in place, perhaps for the sale of a piece of land, but has not yet been completed. So that will create a legal easement. The second one is what's called proprietary estoppel, which I'm not going to get into too much detail, but that's essentially where the servient owner allows the dominant owner to believe that they have got an easement. The dominant owner then goes and does something to their detriment, and then the servient owner seeks to take advantage of it. So say, for example, the property owner of the servient piece of land said, well, yes, of course, you can make use of that roadway, provided that you re-tarmac it for me. The dominant owner then says, okay, I'll re-tarmac the driveway. They do the work, and then the servient owner says, no, actually, I've changed my mind. You can't have a right of way. That's the type of situation where you would find proprietary estoppel. The other time that you will find an equitable easement is where somebody perhaps has an easement which is only linked to a short period of time, for example, a life interest. Because it's not in perpetuity, it's going to be only limited for a certain period of time. That means it can only take place in equity. It's not legal and it's not registrable in the same way. Looking at the scope and extent, So you've got your easement in place, but you need to know exactly what your easement is. You need to know the physical extent, the purpose and manner of the use. So if it's a right of way, is it on foot? Is it with vehicles? Can you drive animals along it? You need to know what limitations there are on the use. So, can it only be used at certain times of day, for example? Express grant, it's pretty easy to do because you've got the words of the documentation, and hopefully you've got some evidence there to say what the intention was behind it as well. Implied gets more tricky. That's when the court will look at the use of the easement, the extent of that use, and also the character of the dominant land. So, for example, if you had a agricultural field as your dominant piece of land, then you might consider that the right of way would be appropriate for you to drive livestock along it. But for example, if we're talking about a residential house, then it's unlikely that that would be considered to be part of the scope and extent of an implied easement in that case. You do get a couple of points that raise out of that. The first one is excessive user. And what that means is when the dominant land changes in some way and the use of that easement changes as a result, then if it's become much more significant, then what you can claim as excessive user, and the effect of that is it will extinguish the easement. The parameters of the easement then, what you need to have a think about with that is the nature of the use, the purpose of the use, and the amount of the use. So a prime example here would be, say you have one residential property at the end of a road, a private roadway. They've got a right of way over that private road to get to that one residential house, but it's quite a big house. So what they decide to do is cut the back garden up into plots. Suddenly you've got 4 houses on that one piece of land. Now, initially, there was only 1 or 2 cars going up and down the track to that property. You're now up to 8 or 10. That would then be considered to be a significant change, even though it's not a change of how it's being used, it's still residential property. It would still come under that excessive user. And the McAdams case that I've put down there is quite a helpful one to refer to because the court broke this down into 2 questions. They said, does the development of the dominant land represent a radical change in its character or a change in its identity as opposed to a mere change, a minor change in its use? And will the dominant land as redeveloped result in a substantial increase or alteration to the burden on the servient land? If the answer to both of those questions is yes, then you're probably going to find that the easement has been extinguished by excessive user. A couple of other things to bear in mind as well. You've got auxiliary use. It could be that you need to have that an extension of the easement in order to make use of your land. So one of the cases this came up in was where there was access needed to adjoining land for car parking in order for a nature reserve to be used. You also have auxiliary rights. So, for example, where you've got electricity lines have an easement to go across land, there will be an implied right that you can also put the pylons on there to obviously carry them across. Looking then at your protection, where are you going to find these? If you've got registered land, the Land Registration Act tells you what you need to do to register these. I'm not going to get into that into too much detail today. Safe to say that essentially you need to make sure that they are noted in some way on the register. If you are dealing with unregistered land, then you are still dealing with the Land Charges Act 1972, and what you would be looking at them is a D3 land charge, and that is something that obviously needs to be checked when dealing with the conveyance of any land. The other thing worth noting is obviously your overriding easements. These were initially governed by the Law of Property Act 1925 and more recently by the Land Registration Act 2002. Again, I'm not going to go into too much detail, but what these are easements that may not be immediately apparent when you're inspecting the site, but you should be able to see them from pre-contract inquiries, or by having a look at local land searches, and so on. How they are dealt with differs depending on whether they are pre or post the 13th of October 2003, which is when the Land Registration Act came into place. But realistically, if you find there is an overriding easement, it's usually because the due diligence hasn't been done in your prior to the actual purchase or the sale of part. At which point it usually results into a negligence claim, which is a bit beyond the scope of what we're talking about today. Looking at interference then. Once you've got your easement in place, you know what the extent of your easement is. What happens if it's interfered with? Well, essentially, it's a private nuisance. So what you need to have a think about then is a party that's claiming an interference needs to show that they're entitled to the benefit of the easement. So they've got the easement. We've looked at how we can establish that already. The nature, extent and scope of the easement, which we've just looked at. And then what they need to say is that it's got to have a substantive nature. The interference can't be trivial. It has to be something that is actually substantive. So common issues that I come across quite regularly. First one is gates and locks. Can you put a gate across a right of way? The answer is yes, you can, as long as you give the party with the right of way the ability to open it and get through it as and when they need to. Then it's not a substantive obstruction, even though it can be quite inconvenient. In terms of alternative routes, yes, you can redirect rights of way or redirect where utilities are. However, you have to bear in mind that while this can stop you having an injunction brought against you because the other party is still being able to exercise a right of a similar nature, it won't avoid the need for potentially damages to be paid. So, for example, if you're forcing somebody to move the utilities, then you'll be expected to pay for that movement. If you're forcing them to change the right of access that they're using and that results in some sort of economical loss, then again, you may still have to pay damages. Parking. Again, it is fine to park on or allow parking on a roadway that is being used for access, as long as the party with the right of way still has the ability to make use of that right of way to the scope and extent that you would expect. So as long as they can still get their car along it, then that's not going to be something that is seen necessarily as a substantive obstruction of their right of way. In terms of rights of light, I'm just going to mention these very quickly because they're really a session all unto themselves. But the key thing about right of light, interference with a right of light is not a right to a view. It's not a right to how much sky you can see out of your windows, which is a common misunderstanding. What it is, it's a right to the quality of the light that comes through the window or the aperture of a building. And the way that it's been described is if you're interfering with the right to light, it's got to be such a deprivation of light as to render the occupation of the dominant land uncomfortable in accordance with the ordinary ideas of mankind, which was a quote from Coles and Home and Colonial Stores, which was more recently reinforced by the Carr Sanders case, where it said basically the property has to be left adequately lit for all ordinary purposes for which the property might reasonably be expected to be used. So where does that leave us? Well, essentially, it's a quite complex set of calculations that need to be done by a specialist rights of light surveyor. But as a rule of thumb, if the room in which the light has diminished by more than 50%, so if it's more than 50% darker in that room, then you may have an actionable interference there for a right of light. Finally, the last thing I've just mentioned there in terms of interference is that you've got to bear in mind that there are ways in which the local authority, under statute, under Section 203 of the Housing and Planning Act 2016 particularly, can legally interfere with rights of way. What that section allows local authorities to do is to override easements and other rights in land that it's appropriated for planning purposes. So it can interfere with an easement, right or advantage annexed to land. It can adversely affect other land, including natural rights to support and so on as well. It's worth as well remembering it's not just the local authority, but it's also anybody else who is deriving title from the local authority can also use that statutory right to interfere with easements, which is not good news for some of the clients that we come across, unfortunately. So moving on then to remedies, because I'm conscious of time. What your remedies are fairly standard in terms of a declaration, which is that your easement exists. If you get a declaration from the court that the easement exists and the extent of that easement, you can go off and you can register it and protect it, as we've discussed earlier. The other option is an injunction. Now, an injunction either can be mandatory, so it can tell the defendant to do something, prohibitory, it can tell them to stop doing something, so it can tell them to do something, they must let parties cross their land or stop obstructing the right of way, or it could be something which is under a principle called quia timit, which orders the defendant to act in such a way as to prevent further future harm occurring. So perhaps they need to stop doing something which is interfering with the ability to exercise an easement. Damages, which I mentioned before, are common law damages. So the idea is if a party is out of pocket, then they should be put back into the position that they would have been had the interference not taken place. It's also something that can be used by the courts in place of an injunction. So if they think that actually if we compensate you, that can make up for the issue that may otherwise have given rise to an injunction, then they will do that. But actually, more commonly when you're dealing with easements, it's found that damages aren't going to be sufficient and the injunction is granted. The final thing there is abatement. This is a self-help remedy. And what it does is it gives parties a right to enter onto servient land in certain circumstances, and they can remedy the interference. It can only be used where a cause of action exists, so it can be used, so for example, to move an obstruction that's in a right of way. So, for example, say somebody has put their bins out into an access way, absolutely fine for you to get out of the car, go push the bins back onto their land so that they're no longer obstructing the right of way, and then to carry on along that right of way. There are a couple of limitations to what you can get away with abatement, because I do know in some circumstances parties think that is free rein to start getting their own back on the neighbour who's frustrating them. It's only appropriate in simple cases where there's an immediate remedy is needed. If there's more than one way to abate the nuisance, it's expected that the party should use the least mischievous method. So they need to be reasonable in what they're actually doing. They mustn't cause any unnecessary damage. They can't resort to abatement if a court has already refused a mandatory injunction. So if the court said you can't have an injunction, they can't just carry on themselves and claim that they're abating the nuisance. It's got to be exercised properly. And unless it's an emergency or there's no need to go onto someone else's land, then ideally you should be giving notice. So it's worth saying to clients, if you're looking at this yourself, thinking, well, what can I do? But it's only more minor things like moving bins back out of the way, or cutting a piece of hedge back, or something similar that is going to stop the obstruction. It's got to be fairly simple and fairly small for you to be able to claim abatement successfully. So I'm just going to spend the last 5 minutes then just having a think about approaching disputes. For those of you who've listened to the Boundaries webinar, you'll find that this is fairly similar to some of the things that I mentioned when we were dealing with boundaries, and you will find that actually easements and boundaries quite often go hand in hand. Part of the reason being, if you're looking at the scope and extent of an easement, quite often you need to know where the boundaries of the dominant and servient land are. So quite often you're dealing with the claims are actually different heads of a similar set of facts. So first off, you need to know what's the real issue, what's the real problem here. Is this something personal? Is there actually a problem with the access, a problem with the support? Is there a problem with how they're getting access to their utilities and so on? What's the real issue that's causing the problem here? Because quite often it's not just as simple as, well, I need to be able to drive my car up and down that road. How much is it really worth? Is this something that a party is doing because they really need it? Or is this something that a party's doing because they perhaps don't get on with that neighbour and they just fancy having an extra access way or an extra gate at the back of their garden? They really need to know why they're doing it and what's it worth to them. How much do they actually want to pay for this? Because, as I said, it's a complex area of law, so the disputes in this area quite often become expensive very quickly. Beware of the point of principle. If it's a point of principle, it's going to get very expensive, and it's likely that the parties are going to be less practical, which is why it really helps to have those discussions or have a think about early on, what is it we're actually trying to achieve here? If it's just to have a go at the next door neighbour, it's going to get expensive very quickly. If there's actually something that specifically needs to be achieved, it's much easier to keep costs under control, and it's much easier to get a better result that we're all going to be happy with. And all of this really comes down to that overarching concept from the civil procedure rules of proportionality. How much effort you want to put in really depends on what you're trying to get out of it. So when you're looking at resolving disputes, you've got your toolkit. And you have to have a think about what you're using. Now, the pre-action protocols, again, there isn't a specific one for easements like there is with boundaries, so you'd be under the general pre-action protocol, but it does push you towards really thinking about your case and having a look at what forms of alternative dispute resolution you might be able to use. Now, negotiation is the most obvious one, getting the parties to speak to each other. There's also the option of expert determination, so you can get a surveyor, for example, to come in, have a look at the deeds, have a look at the land, and decide where those easements reasonably might be or what evidence there is of them. Not quite as easy to do necessarily as your boundaries, but it still is possible, and the parties would need to agree to be bound by whatever is determined. Alternatively, there is mediation. Now, mediation is probably the most useful tool, I would say, for being able to resolve your easement disputes where negotiation fails. So the reason for that is because, as I said before, quite often the issue is not as black and white and simple as the easement that may or may not be granted. Quite often there are a number of factors that need to be taken into account. There is a bit of give and take to make something practical that works on the ground. Now, the court, and certainly an arbitrator and so on, do not have the scope to be able to order things that are more creative and more tailored to the needs of the party, whereas through mediation you can have some give and take, and there is that ability with a skilled mediator to help you actually craft a settlement that is practically going to work going forwards. Another thing that's coming in, which is being used more and more now, is early neutral evaluation. This is taking the preliminary case either before a judge, if you're in a court which is running that scheme, or before an independent party such as a QC, and asking them if that case was brought before them, how do they think it would be decided? And again, that often gives parties a really early steer towards settlement. Your other option there is arbitration. Arbitration is very similar to your litigation process, but it is private. You pick your arbitrator, and you don't have the normal delays that are in place with having to wait to go through the court system, so it can actually be somewhat cheaper as well. But the idea anyway, certainly behind all of those save for arbitration, is to get to settlement. Again, settlement, you might not necessarily have that wonderful moment where all the parties are best friends again, but really you want to leave them in as good a position as possible. So it needs to be practical. It needs to be something that's going to work in the future. So it needs to take into account how the land's going to be used, what the plans are for the future. Are they still going to be neighbours? Is one party deciding to sell their property? You need to make sure that the real problem has actually been solved, so that the parties will be happier. And this is why often settlement is much, much better than taking it to court. Court, everybody comes out, bruised feelings, even the winning party's out of pocket, and generally the remedy that you're going to get is not tailored enough to be adequate to really solve that problem. Practicalities of your settlement agreement, make sure it says who's going to do what and when, who's going to pay, how and when, and make sure it takes into account any third-party permissions. If you don't think about these things when you're putting your settlement together, what you can often find is a secondary argument comes up afterwards about what was or was not actually agreed. And then that final thing that I mentioned previously, for those of you who have been on my webinars, is you should always ask, can the parties actually live with the settlement that they've reached? I mean, I always put that litmus test in there again, which is if I say to a party, when you wake up tomorrow morning, how are you going to feel about this settlement that you're about to sign up to? And if they say, I feel like a weight's going to be lifted, I'm going to have some relief, I can actually move on, I can get on with work, or I can get on with my life, then you've probably done the job. If they say, oh, I'm not sure, I'm not sure if I fixed this, I'm not sure if I fixed that, or maybe I'll regret it, maybe I'm selling it a bit short, then that's unlikely to be something that's going to really solve the problem, and there is probably going to be secondary issues down the line. So the key really to understanding how to deal with easements is very simple. It's to understand what the real problem is, and then decide what you actually need to get out of it. What do you need? What's a nice to have? And then be proportionate in how you then approach it on that basis, and be pragmatic in using that toolkit in order to get to a settlement that really works. So that has been an incredibly quick whistle-stop tour through easements. It's, as I said, quite a complex area, but hopefully it's given you some food for thought. If you have got any other questions, then please do feel free to email me or call me anytime. Also, if you have any suggestions for other topics that you would like to see in our webinar series, then please do let me know. Thank you very much.